Now that David is here, we can begin. So the Subcommittee on Capital Markets and GSEs committee was hereby called to order exactly at 2 o'clock. Thank you, the gentleman from Arizona, for joining us. Today's hearing is entitled Examining the Agenda of Regulators, of SROs, and Standard Setters for Accounting, Auditing, and Municipal Securities. And so without objection, the chair is authorized to declare recess of the subcommittee at any time. Thanks, members of the panel, for being here. And I'll begin by recognizing myself for 5 minutes for an opening statement. So since 2011, one of the primary objectives of this subcommittee and of the full Committee of Financial Services has been to hold regulators and other governmental bodies accountable to the American public, who, lest we forget, ultimately we're the ones that pay the cost and have to contend with rules and regulations that are issued out of Washington. In the last 3 years, our subcommittee has received testimony from the heads of a number of offices within the Securities and Exchange Commission, the SEC, including our most recent hearing that was just back in April, when we heard from the chief economist, the Office of Compliance and Inspection, the Office of the Whistleblower, and the Office of Credit Ratings. These hearings that we've held have allowed our subcommittee to take a deeper dive, as we call it, into the regulatory apparatus of these various agencies so that we can better understand how they operate and what their agenda is, so to ensure that they are actually carrying out their statutory missions. So if someone wants to step back, we may have a bit of a Noah's Ark here on the panel in terms of the breadth of the issues that we'll be able to cover between the ones I listed, municipal security regulations, as well as accounting and auditing. In all that, I'm particularly pleased that we're able to hear from the PCAOB and FASB today. It's been, as you know, a while since you have last testified, and there are a number of areas within your jurisdiction that I think members will be interested in. In the time that I have left, let me just highlight a few areas of particular interest that I'm looking forward to hearing from you today, although certainly this is not an exhaustive list. First one is related to enforcement. As members are aware, the subcommittee has spent a great deal of time examining and also criticizing the lack of due process protections that exist for respondents who are the subject of an administrative proceeding at the SEC and other agencies. There are few issues that are more important to Congress than upholding the rights of Americans to defend themselves when the government brings a charge against them. But in today's enforcement world, there exists an anomaly, and the proceedings initiated by the PCAOB are held in private and are only made public if they are then later on referred to the SEC. This obviously contrasts sharply with practices over at the SEC or FINRA, where charges against an individual or firm are made public as soon as they are brought. Even as someone who has long been concerned about government overreach, I can't bring myself to find a good reason for why an enforcement proceeding against an auditor should be treated any differently than against a proceeding against a broker-dealer or a proceeding against an investment advisor. It seems that investors have a right to a certain level of transparency. If an auditor of a company they've invested in has serious charges brought against them, that seems to be important information. Certainly, that auditor should be granted every single right possible to defend themselves. But keeping a proceeding quiet means and makes our market less transparent and is potentially harmful to the investor. Second issue I'd like to discuss is what related to the hearings the subcommittee held just yesterday. There we discussed the topic of materiality with regard to SEC filings, of course. Companies, of course, make decisions of what to disclose based off the questions whether they are material to the investors or not. And as we heard from our witnesses yesterday, the long-held definition in this country of materiality has worked well and therefore should not be changed. Well, it seems that the SEC and FASB are working towards a common definition that would provide certainty to preparers and to issuers and investors. What is less certain is the role that the PCAOB is playing and where they are coordinating there properly with both the SEC and FASB. The third and final issue, and I don't think this will come as a surprise to anyone in this room, is the issue of cost-benefit analysis. This committee has made cost-benefit analysis a top priority, not just for the regulators, but for the SROs and the standard setters as well. I understand that some of the organizations represented on our panel this afternoon have made efforts to improve economic analysis, and this committee and myself appreciate that. But as in many things, the devil is always in the details. So I'm looking forward to hearing how each one of your organizations or offices incorporate cost-benefit analysis into either your rulemaking or your standard setting. And with that, I yield back the remainder of my time and yield now 3 minutes to the gentlelady from New York.
Speaking for 1 minute, and yielding 3 minutes to Mr. Sherman and 1 minute to Mr. Perlmutter, who have a great deal of interest in this subject matter. This hearing will cover a range of topics from auditing and accounting standards to the municipal bond market to the oversight of broker-dealers. And as a former city council member, I know firsthand the importance of municipal bonds. They allow cities and states to finance infrastructure, build schools, pave roads. This is a huge market with more than $3.8 trillion in bonds outstanding. And as we look forward to the next Congress, an infrastructure package is supported by both presidential candidates, and municipal bonds are an important part of that. The other main topic of this hearing is accounting and auditing. Accurate and transparent financial statements are absolutely critical to maintaining investor confidence in our markets, and I've always said markets run much more on confidence than they do on capital. And I also want to make sure that we're not needlessly undermining confidence in our own financial system. I understand the current concern that the PCAOB has about firms dragging out disciplinary proceedings, but I'm also concerned that by making these proceedings public, we may be unnecessarily harming the reputation of a firm before any official action is taken. I look forward to the hearing and hearing everyone's testimony, and I reserve my time for Mr. Sherman, 3 minutes, and Mr. Perlmutter for 1 minute.
Mr. Sherman, recognized now for 3 minutes.
I thank the gentlelady for the generosity in the granting the time. FASB exercises tremendous government power. It's funded by a tax. If you don't follow its rules, you go to jail. Yet it gets little attention and is not subject to the cost-benefit analysis requirements suggested by our chairman, nor to the FOIA requirements, Open Meetings Act, or Senate confirmation of its members. That would all be okay if they didn't make one really bad decision, and that was the requirement to write off research expenses. Research is critical to our nation. Congress determined that when we passed tax law last year, providing $11 billion every year to incentivize research by private companies. How many refugees could you feed? How many veterans could we provide better care for? But we've decided it's that high a priority. But our $11 billion to incentivize research is virtually wiped out in its effect by an unheralded decision made, I think, 30 years ago by FASB to say that we're going to violate all accounting theory and instead require companies to write off research expenses. Now, if we had that rule for inventories, if you bought inventory for your store, you had to show that as an expense, retailers couldn't carry inventories. But we say that you match the expenditure with the revenue it generates. So you recognize the inventory as an expense when you sell it. With research, instead of writing off that cost as the research is used, as the patent expires, you write it off all the way. That is a system designed to discourage research. And as I say, wipes out $11 billion of congressional effort. It's a clear violation of everything that you learn about accounting theory. It is done solely for convenience, and FASB has been resisting reviewing this for the 20 years I've been in Congress, saying, oh, we'll get to it. Oh, the Europeans are doing something. We'll catch up to them, maybe. Oh, we'll deal with development expenditures. Development expenditures are not our focus here. It is research and experimentation, which is the focus of Congress's $11 billion of credit. So I look forward to FASB coming up with better decisions, and if they don't, then maybe they need a better process. Senate confirmation, FOIA, open meetings, cost-benefit analysis, because the power that they have to control, to be the arbiter that determines what publicly traded corporations do, because they'll do what is necessary to show higher earnings per share. That amount of power shouldn't be hidden in Norwalk, Connecticut. I yield back.
Gentleman yields back, and for the final 1 minute.
Thank you, Mr.
Colorado.
Chair. Thank you, Congresswoman Maloney. Today, it's my hope that our witnesses will focus some of their remarks on how the current regulatory regime impacts small broker-dealers. Since 2011, we've seen a 12.5% reduction in the number of registered broker-dealer firms from about 4,400 down to 3,900. Small firms are being forced to consolidate, merge, or sell in order to achieve economies of scale to compete in today's environment. This committee spends a lot of time discussing the important role independent community banks play in our towns and states. We've considered several regulatory relief proposals targeted at community banks, including tailoring for risk and size, yet we rarely focus on the role of small broker-dealers. Small firm broker-dealers in my district tell me the regulatory pressures are squeezing them, especially the costs associated with a PCAOB audit and supervision requirements on activities happening away from their firms and not as part of their firms. So I'd ask our panelists to please discuss those particular issues that seem to be troubling small broker-dealers. Thanks, Mr. Chair. I yield back.
Gentleman yields back. So now we turn to the panel, and I appreciate all the members of the panel being with us today. Some of you have been here before, some have not. Your complete record, your complete testimony will be made part of the record. We will recognize each of you for 5 minutes. For those who have not been here before, I always begin by saying that in front of you should be a lighting system, a timing system. You'll be recognized for 5 minutes. Green light goes on initially, and then yellow is a 1 minute warning to you to begin to wrap up, if you would please, and then the red is the conclusion of your time. So we'll begin to my left from the SEC, Interim Chief Accountant, Office of the Chief Accountant over the SEC. Welcome, Mr. Brigger. You are recognized for 5 minutes.
Thank you very much, and good afternoon, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. It's a pleasure to be here. I appreciate the opportunity to appear before you today to testify on behalf of the Commission regarding current topics in accounting, in the accounting and auditing profession that impact the capital markets and the related activities of the Office of the Chief Accountant, or OCA. The reliability and the credibility of financial reporting is critical to the proper functioning of our capital markets. As the agency empowered by the federal securities laws to be the investor's advocate, to maintain fair, orderly, and efficient markets and facilitate capital formation, the Commission has the authority and the responsibility to specify the form and the content of financial statements filed with the Commission. Also, the federal securities laws mandate that public company financial statements be audited by an independent public accounting firm that will provide a report as to the credibility and the reliability of the information presented. OCA furthers the Commission's mission by working to enhance the foundation of our disclosure framework, which is the disclosure of reliable and accurate financial information to investors and other market participants. OCA is responsible for establishing and interpreting accounting policy to enhance financial reporting. OCA also leads the Commission's efforts to oversee two entities with key roles in the financial reporting process, which are the Financial Accounting Standards Board, or FASB, whose accounting and financial reporting standards the Commission has recognized as generally accepted for purposes of the federal securities laws. Also, the Public Company Accounting Oversight Board, or PCAOB, which is responsible for overseeing the audits and auditors of public companies and registered broker-dealers. Currently, OCA has been directing significant attention to monitoring implementation activities for recently issued accounting standards. First, the FASB and the International Accounting Standards Board, or IASB, issued largely converged standards for how companies should report information about revenue from customers, which is generally intended to improve existing requirements by eliminating inconsistencies, requiring additional disclosures, and simplifying the preparation of financial statements. Second, the FASB and the IASB's new standards on the measurement and reporting of leasing activities will increase the transparency and comparability among organizations, thereby enabling investors to more readily and accurately understand the rights and the obligations associated with lease transactions. Finally, the FASB and the IASB have issued new credit law standards that will improve and simplify reporting for loans, investments, and other financial instruments. These new standards should improve financial reporting within the United States and reduce country-by-country disparity in financial reporting. OCA is also focused in the area of internal controls over financial reporting. Maintaining adequate internal accounting control promotes reliable financial reporting and encourages investment in our capital markets. Updating and maintaining internal controls will be particularly important as companies work through the implementation of significant new accounting standards that I discussed earlier. Now, I would like to say a few words about the importance of auditors and our oversight of the PCAOB. Independent auditors have been long recognized as one of the key gatekeepers in our investor protection system, and the integrity of this system is supported by the PCAOB's oversight of public company auditors. Recent PCAOB inspection results show promising signs of improvement in many audit firms' quality controls that are designed to ensure compliance with the professional auditing standards as determined by the PCAOB. However, inspections alone cannot fully achieve the objective without the complement of a rigorous and high-quality auditing standards that keep pace with the evolution in financial reporting, the economic environment, and companies' business models. The PCAOB has continued to update and modernize its interim auditing standards that it adopted in 2003. For example, the PCAOB has made significant progress on a major project of vital interest to investors, which is improving the informative value of the standard auditor's report upon which investors rely. I commend the PCAOB for its efforts and its commitment to high-quality auditing standards that have the potential to further enhance the credibility of financial reporting for the benefit of investors. Thank you again for the invitation today, and I'm happy to respond to any questions.
And I thank you. The gentleman yields back. And speaking of the PCAOB, Mr. Doty, you're recognized and welcome for the next 5 minutes.
Chairman Garrett, Ranking Member Maloney, members of the subcommittee, it's a pleasure to be here today. Thank you for the opportunity to appear. As chairman, I want to highlight a few key themes and priorities of the PCAOB. First, I believe the PCAOB is a vital resource, protecting investors and fostering economic resilience by advancing reliable, informative, and independent audits. Second, accurate and transparent financial audits are a key to promoting investor trust and investment that grows capital markets and drives a healthy economy. Third, experience tells us that the PCAOB's role is essential, and our standards and oversight programs are making a real difference on behalf of investors and companies. Fourth, it is critically important that the PCAOB remain vigilant and independent because persistent economic pressures can threaten the integrity of audits. Finally, going forward, a rapidly changing landscape will require that the PCAOB sustain our investment in innovation to meet the needs of investors and enable public companies in our markets to benefit from a lower cost of capital. When investors lose confidence in financial reporting, it becomes more difficult and more expensive to finance the businesses on which our economy depends. Moreover, inaccurate financial reporting can mask poor business strategies or fraud that, if left uncorrected, may result in the misallocation of capital, business failures, and job losses. The PCAOB promotes audit quality through its inspection and enforcement programs, its standard setting, coordination with other regulators, domestic and foreign, and an important investment in economic analysis that we've made in recent years. The PCAOB also benefits from extensive outreach to investors, preparers and audit committees, academics, auditors, and others. As we speak, representatives of the PCAOB are conducting a forum in Jersey City for auditors of small businesses and brokers and dealers. In the PCAOB's 14 years, our inspections have found many examples of high-quality auditing, including evidence of auditors requiring companies to change their accounting or improve their internal controls over production of financial reports. These auditors are the unsung heroes who avert the scandals that don't happen. But our inspectors have also found and reported instances in which firms' audit reports should not have been issued. These instances include audits of some of the largest companies in the world, as well as mid-size and smaller companies. What this points to is smart regulation and accomplishments that are changing the landscape. Inspections have improved audits and changed firms' attitudes and execution. Emerging research on our inspections indicates that when we find audits that are deficient, the engagement teams raise their game without a commensurate increase in fees, but with a statistically significant reduction in restatements. Issuance of regular inspection reports provides meaningful information that didn't exist before, and that helps all parties, including investors, audit committees, and companies that make better decisions. Enforcement has helped root out bad apples and fosters trust in the system. We've issued clearer and better audit standards and have made progress in improving the relevance and transparency of audits. Markets will soon have useful information to differentiate auditors based on the basis of track records for quality. Awareness of our role and mission is now firmly established, and emerging research suggests that this is helping build public confidence in investing. The PCAOB has helped foster global recognition of the importance of cooperation. Our joint inspection with counterparts around the world have proven to be both effective and efficient. The PCAOB has established a Center for Economic Analysis, headed by Luigi Zengales of the University of Chicago, to further incorporate meaningful economic analysis in all aspects of our work. I firmly believe that through these accomplishments, the PCAOB has played a part in helping our economy and capital markets be resilient and grow. As we go forward, we must continue to invest in staff skill sets, information technology, and analytics. The audit of the future will need to take advantage of big data, and we will need to stay ahead of that curve. Our 2017 budget is still under development in consultation with the Commission, which must ultimately approve it. I should point out that by law, our budget is funded primarily by public companies, brokers, and dealers. In order to adequately address priorities, the PCAOB needs to at least maintain the current budget level. I do anticipate the need for a small increase over our $257.7 million budget for 2016. This would be for the cost of living, annual merit increases, as well as expected expenses for travel, particularly for inspections, information technology, including cybersecurity and facilities. But we do have a keen sense of stewardship. It is my goal to accomplish our objectives through careful and continuous assessment of the best use of our resources without a significant increase. In conclusion, I appreciate the subcommittee's continued interest in our work and will be happy to answer questions. Thank you.
Thank you. From FASB, Mr. Colden, thank you for being with us. Recognized for 5 minutes.
Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. Good afternoon. My name is Russell Golden, and I am the chairman of the Financial Accounting Standards Board. Established in 1973, the FASB operates under the oversight of the Financial Accounting Foundation, a private sector nonprofit organization. Through authority established by Congress, the SEC has recognized the FASB as the designated accounting standard setter for public companies. The objective of financial reporting is to neutrally depict the economics of a transaction and thus provide financial information that is useful to existing and potential investors, lenders, and others. Accounting standards, however, are not intended to drive behavior in a particular way. Rather, they seek to present financial information so that users can make informed decisions about how to best deploy their capital. U.S. GAAP is essential to the efficient functioning of the U.S. economy because investors, creditors, donors, and other users of financial reports rely heavily on the information that they contain. The FASB's goal is to improve financial information that is useful to investors and other financial statement users in making capital allocation decisions. It is important to note that although the FASB has the responsibility to set accounting standards, it does not have the authority to enforce them. That falls to regulators like the SEC and the PCAOB. An independent standard-setting process is integral to producing high-quality accounting standards. The FASB sets accounting standards through processes that are open and that encourage input from all stakeholders. This involves, among other things, proactively requesting meetings with stakeholders, including a wide range of investors, auditors, and issuers. These meetings help us to assess whether the proposals or existing standards will lead to better information as well as to assess the related costs. Our comprehensive procedures permit timely, thorough, and open study of financial accounting and reporting issues. Because we understand that the FASB's actions affect so many stakeholders, the procedures also encourage broad public participation throughout the standard-setting process. The FASB supplements its direct outreach by meeting regularly with numerous advisory groups and with staffs of the SEC, the PCAOB, and banking regulators. This broad consultation provides the opportunity for the FASB to hear and consider all stakeholder views and to identify unintended consequences. The FASB is keenly aware of the need to balance compliance costs with the benefits investors and other users of financial reports gain from the improved information. The FASB's broad and inclusive process helps us to assess these factors and strike appropriate balances. The FASB exercises its judgment after considering relevant research, analyzing stakeholder views, and carefully deliberating issues. The FASB's role does not stop when a standard is issued. An important part of the FASB's mission is to monitor implementation and assisting preparers and other practitioners in their understanding and ability to consistently apply a new standard. Further, we ensure that stakeholders have sufficient time to transition to a new standard, and our goal is to be in a position to help them facilitate a smooth transaction. The FASB recently completed a number of amendments to U.S. GAAP designed to improve transparency and overall usefulness of information provided in financial reports, as well as reduce complexity. The most significant amendments are related to the recognition of credit losses and lease accounting. The FASB has a number of ongoing projects, including a disclosure framework project and materiality intended to increase the utility of information disclosed in the financial statements. Stakeholders have also prompted us to look at 4 financial reporting areas of concern, namely intangible assets, including research and development, pensions and other post-retirement benefit plans, distinguishing liabilities from equity, and reporting performance. In conclusion, I would like to emphasize that the objective of financial reporting is to neutrally depict the economics of a transaction, and that it is important for members of Congress and the American public to know that the FASB's accounting standard-setting process is robust, transparent, and accountable. Thank you for the opportunity to provide this brief overview of the FASB and its priorities for the year. I would be pleased to answer any questions.
And thank you. Moving next to the Director Office of Municipal Securities at the SEC. Ms. Kane, welcome. And you're recognized for 5 minutes.
Good afternoon, Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. Thank you for inviting me to testify on behalf of the U.S. Securities and Exchange Commission regarding the activities of the Office of Municipal Securities. The office supports the Commission's mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation by overseeing the municipal securities market, administering the Commission's rules pertaining to municipal securities brokers and dealers, municipal advisors, investors in municipal securities, and municipal issuers, and coordinating with the MSRB on rulemaking and enforcement actions. The Commission created the office as an independent office that reports directly to the SEC chair as required by the Dodd-Frank Wall Street Reform and Consumer Protection Act. The office's current activities generally fall within the following 3 areas. First, municipal advisors. Second, market structure and disclosure initiatives. And third, regulatory coordination. The Dodd-Frank Act required municipal advisors to register with the SEC and to comply with MSRB rules. The Commission adopted final rules for municipal advisor registration in September 2013. The office has significant responsibilities relating to the implementation of the municipal advisor registration rules, including providing interpretive guidance to market participants, reviewing and processing MSRB rule filings related to municipal advisor regulation, and overseeing the registration of over 650 municipal advisory firms. The office also consults with the Commission's Office of Compliance, Inspections, and Examinations regarding municipal advisor examinations and coordinates with the MSRB and FINRA to help promote fair and uniform application of new rules to municipal advisors. With respect to market structure and disclosure initiatives, the Commission issued a report on the municipal securities market in July 2012 that recommended a number of possible actions to improve the municipal securities market in these two areas. In a June 2014 speech, Chair White discussed 3 of the report's market structure recommendations with respect to the fixed income markets, and steady progress has been made on these initiatives. First, the Commission approved the MSRB's proposed rule change to require brokers, dealers, and municipal securities dealers to seek best execution of customer transactions in municipal securities. And the MSRB and FINRA issued guidance on their respective best execution rules. Second, the MSRB and FINRA have filed proposed rule changes with the Commission to require broker-dealers to disclose markups and markdowns to retail customers on certain principal transactions for municipal, corporate debt, and agency securities. And third, the office continues to work with the Division of Trading and Markets to consider ways to enhance the public availability of pre-trade pricing information for municipal and corporate bonds. The Division of Enforcement's Municipalities Continuing Disclosure Cooperation Initiative, a program for municipal issuers and underwriters to self-report federal securities law violations, has focused significant attention on compliance with the continuing disclosure requirements of Rule 15c212 and disclosure practices more generally. The self-reported violations have provided the office with valuable information as to how Rule 15c212 is working and will help us determine where best to channel our efforts going forward. The office regularly coordinates with other regulators in the municipal securities market. The office is responsible for reviewing and processing all MSRB rule filings on behalf of the Commission. The office also regularly meets with the MSRB to discuss rulemaking, examination, and enforcement activities in the municipal securities market. And the office leads the semi-annual meetings with the MSRB and FINRA as required by the Dodd-Frank Act. In addition, the office also works with the municipal securities industry to educate state and local governmental officials and conduit borrowers about the Commission's rules. Thank you again for having me here today, and I'd be happy to answer any questions.
Thank you, Ms. Kane. Ms. Kelly, Executive Director, MSRB, just making reference to you.
Thank you.
Welcome, you're recognized for 5 minutes.
Thank you. My name is Lynette Kelly, Executive Director of the Municipal Securities Rulemaking Board. On behalf of the MSRB, which regulates the $3.8 trillion municipal securities market, I appreciate the opportunity to testify today. Since the enactment of the Dodd-Frank Act in 2010 and the 2012 release of an SEC report on the municipal securities market, the MSRB has made significant strides in fostering a municipal securities market that provides investors and state and local government issuers with an unprecedented level of transparency. In 1975, Congress created the MSRB under the Securities Exchange Act of 1934 as an SRO with the mandate to regulate the activities of broker-dealers and bank dealers that buy, sell, and underwrite municipal securities. We are a 501c6 organization governed by a 21-member board of directors with a majority of public members. The MSRB is overseen by both Congress and the SEC, and our rules generally must be approved by the SEC before becoming effective. Our mission is to protect investors, state and local government issuers, other municipal entities, and the public interest in promoting a fair and efficient municipal securities market. The MSRB is unique amongst SROs in that it does not examine for compliance with or enforce our rules, but we do play a supporting role for those organizations that do, including the SEC, FINRA, and the bank regulators. Congress expanded the MSRB's authority under Dodd-Frank to include the regulation of municipal advisors. those professionals who act as fiduciaries to state and local governments. Congress also expanded our original mandate to protect investors to include the protection of state and local government entities. MSRB Chair Nat Singer wrote to this committee earlier this week detailing the MSRB's progress in advancing this expanded authority through its establishment of our core regulatory framework for municipal advisors. The MSRB is also working to enhance market transparency through 3 avenues: rules for financial professionals informed by economic analysis and regulatory efficiency measures, improved access to market information through enhancements to our EMMA website, which provides free public access to municipal disclosures and data, and education for issuers on their disclosure responsibilities. First, we're improving transparency with rules intended to ensure that retail investors in this market have a more detailed view of the market, including dealer compensation. A new MSRB rule proposal on that topic requires dealers to disclose markups and markdowns to retail customers on certain principal transactions. This and other MSRB rules benefit from a 2013 MSRB policy to formally integrate economic analysis into our rulemaking efforts. In addition, the MSRB has undertaken a multi-year initiative to review the totality of our rulebook, with the result of streamlining, clarifying, and modernizing a number of rules. Secondly, the MSRB has greatly enhanced municipal market transparency through new tools and resources on our EMMA website to improve retail investor access to important market information. EMMA also offers tools and features that support issuers in making full and timely disclosures to the market. This is a topic we underscore through our 3rd avenue for enhancing transparency: education. When state and local governments issue most types of municipal securities, the issuer or obligated person generally must agree to provide ongoing or continuing disclosures. We've consistently called for better disclosure, better quality, and more timely disclosures through market education initiatives, including disclosure of bank loans and other direct purchase debt, which is not currently subject to SEC disclosure requirements. More generally, the MSRB highlighted for the Congressional Task Force on Economic Growth in Puerto Rico principles and practices that any municipal issuer should consider to ensure timely and complete disclosures to the market. Attached to my written testimony is a comprehensive MSRB report card that shows the progress that we've made on numerous initiatives aligned with those recommendations contained in the 2012 SEC report. I would be pleased to provide this committee with further detail on these and other initiatives, and again, very much appreciate the opportunity to testify today.
Thank you. Mr. Colby. Chief Legal Officer,
Chairman Garrett.
welcome, and you're recognized for 5.
Oh, sorry. Chairman Garrett, Ranking Member Maloney, and members of the subcommittee. I'm Bob Colby, Chief Legal Officer of the Financial Industry Regulatory Authority, or FINRA. Thank you for the opportunity to testify today. As you've now heard twice before, the municipal securities market is overseen via a well-developed collaborative relationship between the MSRB, FINRA, and the SEC. The MSRB has responsibility for adopting rules relating to the municipal securities market. FINRA serves as the examination, surveillance, and enforcement authority for its regulated firms, and the SEC oversees the activities and approves the rules of both FINRA and the MSRB. Effective coordination among these regulatory bodies is achieved through both leveraging of resources and collaborating on many financial, operational, and business conduct topics. FINRA examines for and enforces compliance with the federal securities laws and rules by broker-dealers engaging in municipal securities transactions. In addition, since the passage of Dodd-Frank, FINRA has examined its broker-dealer activities as registered municipal advisors. In doing so, we coordinate closely with the SEC and the MSRB, and we have a specialized team that acts as a central point of contact with the SEC and the MSRB. As part of this coordination, FINRA requests interpretive guidance from the MSRB regarding its rules and provides information to the MSRB about FINRA's municipal securities market examinations and enforcement actions. FINRA also participates in formal periodic meetings with the MSRB and the SEC to discuss timely issues arising from current examinations. Each year, FINRA and the MSRB collaborate on municipal securities regulatory priorities, leveraging, among other things, regulatory intelligence gathered from current year examinations, new rules, rule interpretations, and emerging issues. FINRA then performs a qualitative and quantitative risk assessment of each municipal broker-dealer and municipal advisor to determine its municipal dealer exam priorities. FINRA conducts on average about 500 municipal broker-dealer and 60 municipal advisor examinations annually. In recognition of the unique characteristics of the municipal securities market, FINRA operates specialized exam teams for the largest, most complex municipal broker-dealers and municipal advisors. We also conduct market surveillance of municipal securities transactions using a risk-based approach.
What do you mean?
FINRA works closely with the SEC and the MSRB to develop regulation for the fixed income market that's consistent yet calibrated to reflect the unique regulatory needs of each market. In particular, FINRA works with the SEC and MSRB and focuses on initiatives designed to enhance transparency and promote better execution quality in the fixed income markets. One of these initiatives, which has been mentioned already, involves proposals that the FINRA and MSRB recently filed with the SEC that would require additional pricing information to customers on their trade confirmations. Putting additional pricing information in the hands of customers will better enable them to evaluate the cost and quality of the services that firms provide. FINRA and the MSRB also jointly conducted investor testing to evaluate the potential benefits of the proposed disclosures. We look forward to evaluating the comments that will no doubt be received on the proposal and coordinating with the MSRB on this and other issues. I appreciate the opportunity to testify today and would be happy to answer any questions you may have.
Thank you. Thank you very much. So I said at the, I'll recognize myself for 5 minutes. I said at the outset that our hearing today is examining the agenda of regulators, SROs, standard setters for accounting, auditing, and municipal securities. We were saying that this, in being done through one panel, really could have been two. But let's delve into it. And I guess I'll start off with PCAOB, Mr. Doty. Reading through your testimony and hearing you today, as you know, you mentioned in your testimony that, and I mentioned in my comments, PCAOB enforcement proceedings are somewhat of an anomaly, right? In that they're held out of the public eye, unless both parties consent. Essentially, I guess you would say, grants a, what do you call, a veto power, if you will, before that gets out. And this contrasts with other folks here, with the SEC, FINRA, and other agencies. And as you're aware, the subcommittee has been, as I've been, one of the critics when it comes to the way in which the SEC and FINRA conducts their enforcement proceedings, and in particular, the lack of due process, and you've probably seen some of my comments of that. But no point of our examination of their practice did we say, you know what, let's just make all of them private and out of the public eye. So just from a practical sense, and I think you'll probably agree, if you were an investor in a public company and that company's auditor had a charge brought against them, if you're that investor in that company, wouldn't you want to know whether that charge was brought against them?
Absolutely, Chairman Garrett. If you're an audit committee making a selection of an audit firm,
right,
you might want to know. And our strong hope for this, the change that you're describing, is that the present situation as an anomaly creates harm. It harms when we go after the bad apples. They continue to practice, they continue to issue bad audit opinions. They compete with the vast majority of good auditors who are doing conscientious work, and we think that's unfair.
That's true. That's true. And I wasn't even thinking from the audit committee perspective, but just from the investor, but that's true. And I've said it, but does this type of enforcement secrecy exist anywhere else that you're aware of within the whole regulatory framework? Certainly not right here, but elsewhere. particularly within the banking or the securities area, the secrecy aspect.
We see no reason why auditors.
Yeah, but you don't see it anyplace else?
No. No, we don't. It's a general practice in federal agencies and administrative law and other areas that the public knows when we have made a determination that auditor conduct is sufficiently egregious and an extreme departure from professional standards, and that we've brought charges.
So, and that's interesting. And so under the Grassley-Reed Senate bill, you mentioned that in your testimony, I'll be introducing a version of that over here. The investigation portion of it, however, would still remain private, correct? Right.
It would, absolutely.
And this was an argument made up years ago, but a while back, but I assume you'll agree here. Do broker-dealers and investment advisors operate in an environment where reputation and trust matters? And the answer, of course, is yes. And is there anything inherently different between those folks and auditors? Other
professionals who rely on the trust of the public are subjected to public proceedings where they're derelict.
Right. Thanks. Moving next to Mr. Golden. My time's going by quick. I understand the FASB has been working on a disclosure framework. You mentioned it in testimony to improve the effectiveness of disclosures. We had a discussion on that about disclosure. Were you watching our hearing yesterday by chance? Did you tune in?
No, I did not.
You missed it. It was exciting. It was a whole issue of materiality, one of the most fascinating hearings we've held to date. And I wanted to follow up in my last minute on last fall, FASB issued guidance that would revise the definition of materiality for financial statements, though it is based on a legal concept that the Supreme Court has articulated. Can you explain briefly FASB's logic behind that updated guidance and the importance of following the materiality standard articulated by the Supreme Court?
Sure, and thank you for that question. Our intention in the project was to align the existing definition with that of the PCOB and the SEC and remove a change that the board made in 2006 to have the same words as that of the ISB. We thought it was important that the conceptual definition of the FASB align with the SEC, the PCOB, and the laws of this country.
Oh, and let me just jump back to Mr. Doty. So there's some degree, I hear, as far as confusion, as far as where you guys are and where they are. Are you consulting as you're coming up with definitions of materiality?
We do consult, and Chairman Golden is correct that we have continued to observe the law as we understand it on materiality under the Exchange Act.
And we want to make sure
Supreme Court decisions.
Yeah, but my understanding there is some discord or confusion if you at this.
We do consult, and we will be looking to be sure that auditors are auditing in accordance with the legal standard for disclosure policy that the SEC and the FASB established.
And since this is off page, but Ms. Kelly, you raised one issue, I know my time's over, but you brought up the aspect of some degree of materiality. Is there standards, this is just for my information, I just don't understand this. The materiality issue that you were raising near the end of your testimony, right? You with me? Ms. Kelly? At the end of yours, talking about disclosure regimes and materiality issues, is there no?
Well, the disclosure regime in the municipal market is based on a materiality standard.
And is that all this? This is my learning education period. Different definition here? Because you were saying you were going into some of the other areas that needed to be disclosed and some of the issues that were being brought out there, right? That's what by your testimony. So is that something that I need to understand better? I guess I do, as far as the materiality definition over here versus where in your market? Either one? You with me?
I can say during the MCDC initiative, there were certainly market participants that did ask for further clarity on the definition of materiality.
Okay.
And that wouldn't be something that the MSR is within the MSRB's purview.
It's not your authority, but okay. With that uncertainty that I still have in my head on that point, I'll circle back with you. I'll now yield 5 minutes to the gentlelady from New York.
Thank the gentleman for yielding, for calling this important meeting, and for all of your testimony. I've been called to a confidential briefing on the bombings that terrorist attacks in our country, one of which took place in my district. But before I leave, I wanted to ask Mr. Colby about the proposed rule to require the reporting of FINRA's reporting of Treasury trades. Certainly, our Treasury market is the deepest and most liquid and the world and tremendously important to the financial markets and very, very important to the financing of government. So I wanted to ask you, where does this rule stand? When will it be completed? What is the status of it? What can you tell us about this important rule?
Thank you, Congresswoman. We have filed a proposal to require our members to give us information for purposes of an audit trail of Treasury securities. It's with the Commission. There have been a round of comments. We're about to respond to those comments, and we're hopeful the Commission will approve it shortly.
And so you think it's be shortly? Okay. What do you think of the argument that some people have put forward that the Treasury trades should be reported publicly rather than just to regulators? And do you think there's a risk that public reporting could potentially in some way hurt or disrupt the market?
Well, we believe that the question about dissemination of the Treasury data really is primarily a question for the Treasury Department and the SEC. We responded to their request for us to develop an audit trail. We've made public data with respect to corporate and agency securities, and we heard these same arguments in that context, and so we went through a very methodical process where we put out in the public sphere the most liquid of the security transactions and assess the impact of those before moving on to other transactions.
Well, I'd like to address this question also to Jessica Kane and to you. And would each of you describe the types of enforcement actions you have brought in the municipal market, both with the SEC and with FINRA, and any emerging threats that you see either to municipalities or investors, and how are you addressing them? First, Ms. Kane, and then Mr. Colby, if I could.
At the Commission, we have a specialized unit within the Division of Enforcement. It's the Public Finance Abuse Unit, the PFAU, and their current efforts focus on investigating and pursuing enforcement actions in 4 primary categories: offering and disclosure fraud, broker-dealer abuses, public corruption, and municipal advisors. Earlier, Ms. Kelly referenced the MCDC initiative. I would say the lack of compliance with continuing disclosure obligations was one area that we saw a potential for abuse, and the Enforcement Division, noting this area, brought the MCDC initiative.
Mr. Colby.
Well, our efforts are focused on broker-dealers and municipal advisors that are our members. We've brought a range of cases covering both market transactions and customer transactions. In the customer area, we've focused on suitability issues, the sort of recommendations that are made to customers, and whether they're appropriate for that sort of customers. In the transactions area, we've brought cases on markups, where excessive undisclosed markups were charged to customers, also to failure to report transactions as they should have been reported under the municipal reporting system.
Thank you, and my time is almost up, but I'd like to ask James Doty. It's my understanding that the PCAOB does not currently have a budget request for 2017 because of a unique timeline. Could you explain what the timeline is and discuss in general terms what your views are on your expected budget request?
Yes, Ranking Member Maloney. We are in the process of formulating our budget. That happens as a bottom-up assessment of each program's needs. It occurs with extensive discussions that begin in the spring. We received a lot of feedback and discussion from SEC staff here, which acting Director Bricker has referred to. We will submit a preliminary budget for examination and review at the end of July, which we've done, and that will receive a lot of work, both with the SEC and ourselves, pitching in and meeting frequently. It will culminate with a final budget request on November 30th. That will then be the subject of a hearing by the Commission.
Thank you. My time has expired. Thank you.
Thank you. The gentlelady yields back. Gentleman from Arizona is recognized for 5 minutes.
Thank you, Mr. Chairman. And this is one of those hearings where you sort of get to ask those sort of questions that have bounced around in the back of your head. A decade ago, I was the treasurer of a very large county. And so this is going to be to Ms. Kelly. I signed a lot of bonds in that time. I mean, to the type where you have the hand cramp. But I remember a number of occasions where we were doing a defeasance, a refinance. And typically my job was just, the official of the county putting our name on it, saying, the school district or whatever the taxing district was. And I got loose with some of the fees and costs. And in digging into them, I realized that the legal fees, the rating fees, everything else that goes into that cost stack of this refinance was actually almost as much as the savings on the instrument was going to have to the taxing district. Is there a standard that's articulated that you don't walk in and convince a school district, someone else saying, want you to refinance your bonds because we're going to make a bunch of legal fees on it, but over the next decade, we're going to save you $5,000. I mean, what is the proper etiquette and rules, and has that changed in the decade since I was doing that?
So thank you. The MSRB rules apply to broker-dealers and municipal advisors, and we have rules for each, fair dealing and fiduciary duty rules, for both of those types of professionals that prohibit the charging of excessive fees.
You already see, Mike, because there was no municipal advisors involved.
Right.
And someone handed you a note, you might want to double check that. Because look, we all rely on our experts. Because in this particular case, there seemed to be some extraordinary legal fees rolled into this defeasance. Mm-hmm. And I know that's sometimes uncomfortable, but when we looked at the entire stack of costs, from the rating to the analysis, that, there was really very little savings happening here. Does the entire cost stack get looked at?
Not by the MSRB. We have no direct authority over bond attorneys at all, but there are certain activities at the state level that seek to really make costs of issuance on a bond issue more transparent. So for example, the state of California just adopted a bond disclosure law that would require very detailed information about all of the professionals and the costs that they were, or the fees that they were paid per bond transaction.
Okay, and this is for anyone on the panel, has anyone ever seen a state, municipal government, or even a national organization says, hey, we have a very simple online disclosure. When someone walks in and wants your road district, your sewer district, your school district, whatever, in Maricopa County we have, 3,300 taxing districts, and I think 25% of those have the right to do some type of bonding. Saying, here's our cost. And any taxpayer can log in, see it, and it's a nice, simple, looks like the backside of a yogurt carton of here's our legal costs, here's our rating costs, here's our research costs, here's our certification, here's our, and to see that, and particularly in the occasion of a defeasance where you're moving from one to the other and assuming that you're saving the taxpayers' money. And does anyone know of something like that? Because I'm thinking of the elected officials who may not be from our world of doing finances. How do they get a quick understanding of the cost?
What is fair, what is not? I'm not aware.
What's rational?
I'm not aware of, well, there certainly is no national database that requires municipal bond.
Wouldn't that be a lot easier than a fairly large regulatory statement?
Sure.
Like as you were mentioning, California, which I have a little familiar with, which has, a couple dozen line items and categories in it, and just make it, hey, this is it.
Again, there are certain states that do require disclosure at the state level. I'm not aware of whether or not those are publicly, that information is publicly available, but I take your point.
Okay. If anyone ever comes across something like that, I'd love to read more about that. And with this, I yield back, Mr. Chairman.
Gentleman yields back. Scott's recognized now for 5 minutes.
Oh, thank you, Mr. Chairman. As a co-lead sponsor on Dodd-Frank a few years back, I was happy that the law elevated the attention needed to the municipal securities market by creating the Office of Municipal Securities at the SEC. It's been a long time, indeed, since this committee itself has even had a hearing on municipal securities. So I wanted to ask the panel, especially you, Director Kane, if you could provide us with an update of any emerging threats that you see today, either to the municipalities themselves or to the investors. And I'm particularly interested in this because municipal bonds have been getting a lot of attention in my own district in Georgia, in Cobb County lately because of our brand new spanking Atlanta Braves stadium. And so it's of particular interest to me to make sure things are going to be going smoothly. And so I'd like to know, do you see any threats on the horizon to either the municipalities themselves or to investors, or do we see smooth sailing along the way?
I'm happy to start that off.
Yeah, if anybody else would like to comment, I'd certainly like to cover the waterfront so all of us will know, and we are on C-SPAN, so people across the country will know if everything is fine.
Well, I think I'd like to talk about two issues in particular. The Dodd-Frank Act required municipal advisors to register with the Commission and to comply with MSRB rules. These are important rules that the Commission promulgated in September 2013. The MSRB has rolled out a suite of conduct rules applicable to municipal advisors. And these rules were really designed with the idea of protecting municipalities.
Let me ask you one thing. I think I missed you. Who would register with the Commission again?
Municipal advisors. Okay. These are anyone who would provide advice on the issuance of a bond or municipal financial products, or would solicit a municipal entity or obligated person. Mm-hmm. So the SEC does have authority over municipal advisors with respect to registration, examination, and enforcement. As Ms. Kelly mentioned, the MSRB has recently completed a suite of conduct rules applicable to municipal advisors, including a fiduciary duty rule. So advisors to municipalities are now subject to SEC registration, examination, and oversight, as well as subjected to MSRB conduct rules. These are important rules designed to protect municipalities from conflicted advice and from unregistered financial advisors advising them on transactions without the municipality's best interests at heart. Another area that we have been focusing on at the SEC is compliance with continuing disclosure obligations. The 2012 report that the SEC Commission put out noticed that there was widespread failures to comply with continuing disclosure obligations on the part of municipal issuers. To correct that widespread activity, the PFAU, the Public Finance Abuse Unit at the Commission's Enforcement Division, launched the MCDC program. And this was a voluntary self-reporting program whereby issuers and underwriters could self-report violations of the federal securities laws.
Yeah.
It's been an incredibly successful program from the perspective of my office in terms of focusing compliance by municipal issuers and underwriters on continuing disclosure obligations and ensuring that investors get the information that they need.
So let me ask you this too. Also in my state, at the same time we were building the new Atlanta Braves stadium, on municipal bonds in the area. Downtown in Atlanta, we're building the new Falcon Stadium in municipal bonds. And there was some concern about, is this too much in one area? And particularly because municipal bonds now are becoming the favorite way of building these huge mega stadiums now. Do you all see any threat in that? Is that, I mean, we're doing well, given we're doing them all at the same time. We got both stadiums supposed to come on in 2017, so that'll be interesting. But is that a threat? Is that something communities need to be aware of, not to overload?
The decision to incur debt is a decision that is made at the state and local government levels. The SEC has authority over municipal advisors, municipal securities brokers and dealers. The SEC also enforces the anti-fraud provisions of the federal securities laws with respect to disclosures made by issuers to investors.
Right, so we're safe.
The gentleman's time has expired. Thank you. Gentleman from Texas, recognized 5 minutes.
Thank you, Mr. Chairman. Thanks for holding this hearing. One of the things I wanted to talk about a little bit is the municipal bond market and the transparency in that market. Ms. Kelly, I think I'll start with you. You recently put out a new proposal that would require the dealer to disclose the markup. Kind of walk me through kind of where you are with that process and what are some of the pluses and the minuses of that proposal.
Certainly. The MSRB worked actually very closely with FINRA so that there could be a uniform standard for disclosure across the fixed income markets. There were over 2 years of notice and comment on various kinds of disclosure proposals, including price reference, a reference price on a confirm, which eventually evolved into a markup disclosure requirement. This is a great example of where a really thorough independent economic analysis worked, and it was pretty clear that the price reference standard didn't make sense from an economic analysis perspective. So fast forward, in the last 2 months, both FINRA and the MSRB filed rule proposals with the SEC. They're in public comment right now, public comment directly to the SEC, which MSRB and FINRA will respond to. And it is expected that there will be an effective date, possibly as long as 12 months. The effective date, if approved, has not been set yet. This kind of disclosure requires some very significant technological changes and confirmation disclosure changes, so we want to make sure that the industry has enough time to implement those requirements.
Yeah, well, I mean, I think that the interesting thing to me is the technology in the securities area has, been 4x, and so, but it seems like the municipal bond market has trailed that, and I think one of the things that concerns me about the municipal bond market is that kind of the lack of information from an investor standpoint. I think most sophisticated investors understand that municipal bonds can be less liquid than other types of securities. But if we had more information, then as investors, we'd actually know how illiquid that is. And for example, the last time that bond traded, for example.
Certainly.
And what you can find on the out on the web right now, you can find the ask, but you can't find really information on what maybe the current bids for those securities are, or what was the last trade and the last trade date. So are those some of the things that are being considered, or what? Kind of give me some insight in that.
Certainly. An equally important activity at the MSRB, equal to rulemaking, is transparency in the market. And in 2009, the MSRB launched the EMMA website, which is the central location available for free and really geared to the retail investor that has information on over 1.3 million individual municipal securities. That includes offering documents, ongoing disclosures, trade data, short-term interest rate resets, market information, as well as other tools and information useful to better understand the market. You're right that municipal bonds generally don't trade very frequently. We have a price discovery tool which allows a retail investor to ascertain similar securities and look at their trading patterns to get a better sense of the value of their security. Perhaps we need a little bit more of a marketing budget, but it is really a game changer for the market. And what we have found out with the age of the traditional municipal retail investor happens to be, in the 60 to 80 range. They're not as likely necessarily to embrace technology and to do research on their own. The market generally still is a buy and hold market, but we're very confident that, as their new investors come into the market, that they'll be much more self-directed.
Yep. And one last question. In your cost-benefit analysis that you've done on this particular rule,
On the what rule?
The liquidity issues, did that come up? In other words, if I have to start disclosing, what my markup is, I may not want to inventory certain bonds, and so that might create some liquidity issues. Was that something that was discussed?
Yes, sir. We certainly invite a dialogue with the industry about the costs and the benefits of each regulatory proposal that we issue. Many times we have quantitative information, and sometimes we don't, in which case we'd have to rely on a more qualitative assessment. So that question absolutely is part of the analysis.
Thank you.
Gentleman from California, Mr. Sherman, is recognized for 5 minutes.
Let me first focus on the PCAOB. It's been thought that we should publicize every time they do an investigation. I'd point out that nobody in the room is an accounting firm, but we're all citizens, and as far as I know, none of us have been indicted, but none of us know whether we've ever been talked about in a grand jury. I don't think it would make sense to publish everyone whose name is mentioned in a grand jury. That's why we keep them private. I'll ask our witness from the PCAOB, if it was announced that you were investigating a firm, that would punish the firm. That would hurt the firm's position in the community. It would cost them clients. Would you be reluctant to investigate a firm if you didn't know that they had done any wrongdoing and you knew that by merely announcing the investigation you were punishing folks that may be blameless?
Mr. Chairman, we would not identify witnesses or even announce the fact of an investigation.
Mm-hmm. Oh, I know that's your current policy. What if Congress said that you couldn't investigate anybody until you published the fact that you were investigating them?
We would
that interfere with your work?
Our investigations should be confidential. And as with other law enforcement agencies, including the SEC, we would not seek the authority to announce and do not seek the authority to announce the commencement of investigations or the participants. No more than we would identify the identity of companies that we audit, where we have findings in an audit report, or where we have an investigation. That should be confidential. Mm-hmm. We are seeking only the ability to publicize the facts when we get to the point of filing charges as the SEC.
And then if you file charges, that's public, and there could be, in effect, a public trial or hearing before the SEC?
Well, there would be a hearing at the PCAOB in which those persons charged would be entitled to all of the protections of due process that government agencies afford,
So a secret grand jury and a public trial.
That
sounds familiar. That sounds like how we do business in this country. We don't punish somebody because we want to investigate. I want to go on to Mr. Golden. I know that, the chairman believes in cost-benefit analysis with regulations. You say that accounting standards are not intended to drive behavior, and they're not. But when you violate every accounting principle for the convenience of accountants and provide tens of billions of dollars of punishment to those companies that choose to do research, can you ignore that you are driving behavior?
Well, I've enjoyed the conversations we've had over the number of years regarding the accounting for research and development. As we have completed a number of standards this year, we began to plan our future agenda. And a few months ago, we issued for public comment.
If I can interrupt,
Sure.
I talked to your predecessor. I talked to your predecessor's predecessor. I talked to your predecessor's predecessor. I talked to your predecessor's predecessor. And they've all promised to look at this, and they've all done absolutely nothing. And you sound just like them. So telling me that you're going to finally go back to good, solid accounting of matching of expensing an expenditure when it generates revenue, you know you're not going to do that. I know you're not going to do that. It's pretty clear that your decision-making process is broken. Please proceed.
A few months ago, we issued for public comment 4 very important issues that have been raised by a number of stakeholders. One of those was the accounting for intangible assets, including research and development. We plan to seek feedback throughout the fourth quarter and have a public discussion with our stakeholders as to whether or not we should change the accounting for intangible assets, including research and development. And I look forward to talking to your office about as that process continues.
I look forward to a situation in which you can't build a 2-story apartment building in my community without a public hearing, Freedom of Information Act request, and people paying attention. But you can do damage to the entire state of science and research for decades, and as long as your ruling comes out of Norwalk, Connecticut, nobody pays any attention. There's no Senate confirmation, there's no freedom of information, there's no cost-benefit analysis, and there's no Open Meetings Act. Just because accounting is boring doesn't mean it's not important. I yield back.
Thank you, Mr. Chairman. Mr. Hogan from Illinois.
Well, I do want to express my appreciation to Chairman Garrett for holding this series of oversight hearings on our capital markets. I especially want to thank Chairman Bruce Poliquin for doing such a great job chairing this committee, and I hear Maine is beautiful this time of year, but all of you, grateful that you're here. This is important. Mr. Colby, if I can address my first question to you. As you might be aware, Chair White stated last week that the Commission is close to finalizing amendments on Rule 15b-91 that would require more firms to register with FINRA. I'm hearing concerns about the impact on the options markets if the rule is finalized without changes. Wondered, can you tell me why expanding FINRA supervision over these new registrants would improve option markets?
So the purpose of this rule is to extend FINRA oversight to entities that are trading outside of specific markets, but and to make sure that they're included in the broader audit trail that FINRA currently operates. And so we've been in discussions with a number of the participants for the options markets trying to identify their concerns. We have a filing that's going to go in that's going to have specific changes to our fees that apply to trading, which we know that they support, and we hope to respond to their concerns in other ways through these discussions.
Yeah, I would share their concerns. I mean, I do think from at least an initial look, the proposal scope is maybe broader than intended and really could do, as oftentimes happens up here, harm when we want to do good. Mr. Colby, if I can follow up, I'm also a co-chairman, well, so not follow up, but change a little bit here. I'm a co-chairman of the Municipal Finance Caucus. I'm especially interested in ensuring that we have a highly competitive municipal securities market. I've heard of some unscrupulous marketing practices that would suggest states and local governments are required to retain the services of municipal advisors, despite the statute and rule being quite clear that this is not necessary. I recently introduced the Municipal Advisor Choice Act to address this issue. Is this an issue you've encountered in your surveillance of the municipal securities market, and would you agree that Congress should take all steps necessary to clarify its intent?
Well, I certainly support Congress clarifying its intent. we've seen situations where, and brought up cases where firms acted both as advisors and as underwriters in the situation, contrary to the law.
Okay, well, I hope we will be able to clarify it and make our intent crystal clear. Let me just switch over to Ms. Kane real quick, if I could. As you're aware, Dodd-Frank requires the SEC to promulgate rules to make reforms to money market funds, which will go into effect next month. A significant portion of the $3.7 trillion in outstanding muni debt is held by money market funds. According to a September 16th story in the Financial Times, assets in tax-exempt funds have dropped by nearly 50% since standing at $266 billion at the beginning of this year, and the cost of borrowing for issuers, states and local governments, is already beginning to increase significantly. What cost-benefit analysis did your office conduct on this rule, and how did you contemplate the increased cost in borrowing for issuers, and how did you weigh this with investor protection?
So I'm aware of the issue that you referenced. The Office of Municipal Securities monitors the municipal securities market and current developments in that market. The Commission's Division of Investment Management is responsible for administering the Commission's rules on money market funds. I'm generally familiar with their 2014 amendments, which I think is what you're referencing, and would note that these amendments are not yet effective. They are scheduled to become effective in October of this year. There are many factors investors may be considering in their determinations in how to allocate capital. The current low interest rate environment may be one of those factors that investors are considering currently.
We may follow up, if that's okay, and find out who we should direct a question to directly of just, again, looking at cost-benefit analysis, certainly seeing higher costs and concern in the significant decrease this year. Let me just have a few seconds left. Let me address my last question to Ms. Kelly, if I may. You note in your written testimony that the MSRB advances transparency in the municipal securities markets in 3 ways. 1, through rulemaking. 2, through your website, the electronic municipal market access, and 3, by encouraging timely disclosures. I wonder if you could please discuss briefly some of your initiatives in this space. I'm sure we can all agree that market transparency is a crucial thing.
Excuse me. Thank you. Yes, on transparency, again, it's really a fundamental activity that we find to be certainly as important as rulemaking. This year, the Board of Directors has approved making third-party yield curves available on Emma, adding a new issue calendar, enhancing the Emma user experience for various types of users for the Emma system, and we're also exploring whether or not there are certain kinds of pre-trade information that might be helpful, especially for retail investors. We want to study the impact of our regulatory framework with continuing our retrospective rule review. And finally, on the education front, we have recently launched our Muni Ed Pro system, which is a learning management system that we're making available to all market participants, and including investors and issuers with courses over this year. We really want to empower market participants to really understand the market, to make good decisions, and to know what kinds of questions to ask their market professionals.
Okay, thank you. Chairman Pollock, you've been very generous, and I appreciate that so much. I yield back to you.
Well, it is the fall in Maine. You're very welcome, Mr. Holgren. Mr. Ellison from Minnesota, please. 5 minutes.
Thank you, Mr. Chairman. My first question is directed to Mr. Doty, Chairman of the Public Company of Accounting and Oversight Board. Section 404 of Sarbanes-Oxley Act is a cornerstone in providing public confidence in financial statements. Section 404 requires firms to include information concerning the scope and adequacy of the internal control structure and procedure for financial reporting in their annual report. What are the benefits of Section 404B to investors?
I'm sorry, sir?
What are the benefits of Section 404B to investors?
Well, it is a fundament of good accounting, we believe, that there be good internal controls. Good internal controls have proven over time, Congressman, to be the best tool we have for early detection of problems and the prevention of fraud.
Thank you. And since Sarbanes-Oxley was passed in 2002, have costs for the implementation gone down? And if we roll this back to cover fewer and fewer companies, what would be the impact?
It's the cost has gone down, as you rightly point out, because companies, I think, have gotten better, and auditors have gotten better at working with companies to spot earlier the improvements in internal controls that are needed. We would like to think that as the process continues to evolve, that without regard to the very largest companies or the mid-size or even smaller companies, there is an advantage to adopting and implementing as the best internal control system that you can find. I'm quite aware of the fact that there's a statutory issue here, and I don't want to suggest that we have disregarded the Jobs Act and the position of emerging growth companies, which have a different and competing statutory purpose.
Are you concerned at all that if Section 404B covered fewer and fewer companies, that some of the internal controls that are so important, as you correctly point out, in my opinion, are you concerned that some of those controls will be relaxed and we could introduce more risk into the system?
Congressman, we do see a change in the view of audit committees and boards, and there is a perception spreading in corporate America, which I think is very healthy, that if you're on a board of directors, you want to know they have good internal controls. One of the achievements of Sarbanes-Oxley, I think, might be that over the time that we have had it and over the 14 years of the PCAOB's existence, the advantages of internal controls for the board of directors as well as the stakeholders is becoming apparent. And so many of the people on audit committees to whom we speak, and we meet with businessmen and audit committee people all the time, we continually hear this said that most responsible directors would not consider going on a board of directors now that did not have an integrated audit of internal controls.
Well, I just want to say that there's a lot of criticism in this institution of Congress about regulation. But Sarbanes-Oxley didn't come about because everything was going great. And if we relax those requirements, I am concerned that some of the trouble that we saw back then could return. That's just my own view. Let me ask you this also, Mr. Doty, regarding the issue of technology. I think technology has always had and will continue to have a transformative impact on the financial statement audit. And I'm eager to see the SEC implement inline XBRL, extensible business reporting language. And I've opposed efforts from certain of my colleagues to reduce XBRL coverage. When it comes to audits, we know that the ability to analyze vast amounts of data, access it remotely, and create digital audit trail will change the audit forever. How will technology impact the accounting profession and the PCAOB?
We are keenly aware, Congressman, of the need to maintain our cutting edge and our investment in innovation. It will be incumbent on us to understand the tools of technology that are being used by audit firms, to appreciate the extent to which they can meaningfully contribute to a better audit. That's a project the firms have now and that will go on for a long time. And it will be important for us to recognize that, to adjust to it, to be able to evaluate how good their tools are and how competent they are at using their tools. That will be a technical challenge for us. We will have to maintain investment in technical skills and in data ourselves to do that.
Well, I've run out of time, so allow me to thank the panel, and I'll yield back.
Thank you, Mr. Ellison. I recognize myself for 5 minutes. Ms. Kane, you run the municipal securities area at the SEC.
That's correct. I'm the director of the Office of Municipal Securities.
Yes, ma'am. When I was the state treasurer up in Maine, I came from the private sector, and we were trying to do things quite differently to save as much money as we could for our taxpayers. And one of the things that was a big surprise to me when I arrived, Ms. Kane, was the history in our state of using negotiated bond sales instead of competitive bond sales. And I always found this quite unusual, especially when we were dealing with a plain vanilla offering, a general obligation offering from State Treasury. In that when the legislature would come to us and say, you know, we need to build a new road or we need to build a new bridge or what have you, or when some of our smaller rural communities needed to pool their offerings and raise money that way. And I know with if the credit's a little bit unusual and a negotiated sale makes a lot of sense, but what we used to do, Ms. Kane, for the first time, is introduce a competitive process. Such that we get all the information to all the investment houses out and say, we're going to market at Tuesday at 10:30. We push the button. We'd sit behind a computer and we watch the bids come in. And I remember we get a dozen or so bids. We would drive down the interest rates in a very transparent way, no hidden costs, and we save the taxpayers a boatload of money. Now, my question to you is, in the work that you do over at the SEC, are states required or municipalities required to employ the services of independent advisors with respect to this function? Because we had a very small staff at State Treasury, and we didn't have the depth of personnel that we needed to get this done. But what I found, it was very refreshing when you had an independent set of eyes and set of experience that could advise the folks that were borrowing the money for the taxpayers of Maine to build the roads and bridges. It was helpful to say, you know, Mr. Treasurer, I think we can do very well with a competitive bond sale here instead of a negotiated one here and not succumb to the pressures of Wall Street. What are your thoughts about that?
Well, the decision to incur debt at the state and local level is a state and local government decision. The decision to hire market professionals is a state and local government decision. The SEC does have authority over municipal securities brokers and dealers and municipal advisors. Certainly, the municipal advisor registration rules bring a new class of SEC registrant into SEC registration exams and enforcement. One of the benefits, as you pointed out, of hiring a municipal advisor as a municipal entity is that that municipal advisor owes a fiduciary duty to the municipal entity client and can help the municipal entity client evaluate the advice coming in from other transaction participants, can help evaluate conflicts of interest. It's someone standing next to the municipal entity, advising them, acting in their best interests.
I always found in our work at Maine State Treasury, Ms. Kane, that in a negotiated sale, there tended to be a lot of hidden fees, and the cost of issuance, where a lot of things could be in there that wouldn't be clear to the taxpayers who are eventually paying for all this. And have you found in your work at the SEC that there have been surprises or abuses in that regard with respect to that type of sale?
With respect to negotiated versus competitive?
Yes, and the cost of issuance.
I'd have to take that back to our Office of Compliance Inspections and Examinations, but I'm happy to get back to you on that.
Would you mind? And we look forward to that, and I thank you very much. Mr. Golden, I know that in the work that you folks do, you try to always assess the cost and the benefit with respect to dealing with the space that you're in. Do you folks have a very rigorous process, not only to look at specific companies, but also in aggregate, look at whole different sectors of the economy when it comes to assessing the cost and the benefit of your regulations?
We do have a very robust and transparent due process. All of our board meetings are in public, and all of our discussions are communicating the basis for conclusion. We do meet with a number of companies. For example, in our recently completed project on expected credit loss, we met with over 200 users and over 100 different companies and received over 3,000 comment letters. What we are trying to do is to understand what is the cost that the company will incur upon transition, and what is the cost that they will incur over time. We then compare that to the benefit that the investor will receive with respect to more information.
Great. Thank you very much. My time has expired. I don't believe there are any more individuals here looking to ask questions of our witnesses today. I'd like to thank all the witnesses today for your testimony, and the chair notes that some members may have additional questions for this panel which they may submit in writing. And without objection, the hearing record will remain open for 5 legislative days for members to submit written questions to these witnesses and to place the responses in the record. Also, without objection, members will have 5 legislative days to submit extraneous materials to the chair for inclusion in the record. And without objection, this hearing is adjourned. I've always wanted to do that.